right. Hello and welcome, everybody. Thank you so much for taking time out of your day to join us. Today, we will be looking at some of the recent laws that are impacting Florida condos and HOAs. So, the title of this webinar is What Florida's Recent Laws Mean for Condo and HOA Communities. During this webinar, you'll have the opportunity to learn more about why these laws were passed and what community associations can do to ensure they are complying. Okay, so we are very lucky today to have two experts on our panel for this discussion. First, we have Louis Orloff, registered investment advisor, and also a chapter delegate of member of the CAI's Florida Legislative Alliance. And we also have Steve Adamczyk, attorney and partner at Varnum. Okay, and then he specializes in condominium and HOA law. And then hosting today will be myself, a customer marketing specialist from Condo Control, and Kim Brown, a senior writer at Condo Control as well. Okay, so before we get started, just wanted to go over some housekeeping and just a few reminders. So this webinar is being recorded. A follow-up email will be sent out to all registrants with the recording link once it becomes available. And then after the presentation, we will have a formal Q&A session. So if you do have any questions, please submit them into the Zoom Q&A at the bottom of your screen, and we will do our best to get to as many questions as we have time for. Please note that all attendees are muted, so you do need to use that Zoom Q&A to ask a question. And then after the webinar, upon leaving the Zoom meeting, a survey will automatically appear in your browser to answer a few questions and gather any feedback. All right, so on our agenda for today, we're going to start by just going through the laws in a little detail. Then discuss the Kaufman language and potential legal challenges, and then go over how both condo and HOA communities in Florida can comply with these regulations and hear more from our expert speakers, and then followed by the formal Q&A. Okay, so I will now hand it over to Kim, and she's going to start by discussing the HB 1203 and HB 1237 website laws. Kim, over to you.
Thank you so much, Rebecca. So I'm just going to cover, what the laws say, and then our experts are in a much better position to explain what that means in the real world. So HB 1203 applies to HOAs, and any community that contains 100 parcels or more must maintain a website or application that can be downloaded through a phone and host digital copies of many of the association's official records. That includes articles of incorporation, CC&Rs, bylaws, rules, current insurance policies, and the annual budget and current certification of each director. HB 1237 applies to condo associations. So prior to 2024, it was 150 units or more, excluding timeshare units, were legally required to have a website or application with similar requirements as what applies to homeowners associations. And now that was changed last year in 2024. So now condominiums that have 25 or more units must have a website or application. And very important to note that the websites must be accessible through the internet, of course, but they also must contain a subpage or a web portal or other secure electronic location that is password protected. And this is because the general public should not have access to all community documents. So it's just a safe place to keep information for members. Okay, so why did this law come into effect? Predominantly, it does improve transparency for owners. They don't have to go to the office or, ask a staff member for something very important. They can get it anytime they need from the comfort of their own homes. It also increases trust between members and the board. It's definitely a more convenient way to share information with owners, and it is generally less expensive for communities instead of having to print and mail documents like that can add up to thousands and thousands of dollars every year. They can simply be uploaded online or emailed to individual members.
Yeah, and
Kim, this is Stephen Amzik, and thanks for having me, first of all. Another addition to the slide is just the efficiency. Official records requests are typically either easy or they're the bane of existence for many of our condo clients. We all know that there are certain owners who are going to request multiple categories of documents every month. That can take dozens of hours of management's time, which is monopolizing the time that could be spent on the entire community. In the same token, you have to balance out the fact that owners have a right to access records, right? Owners have a right to access. And so historically, an owner asks for access and the association has 10 working days to quote unquote make them available. That could include sending them to a website, or it could include inviting them to the office, as you mentioned, or it couldn't include sending them a flash drive, or it could include giving them the file cabinet and just say, go find it somewhere in there. And so I think having the website is both beneficial to the owner and the association, because these are, presumably the commonly requested documents. And so the association can just respond instead of taking hours, just say they're on the website and we know they're because we have to put it there. And secondly, the owner can't be told, hey, even though you're living in Minnesota for the summer, you have to come down to Fort Myers, Florida to take a look at the records. Likewise, they have a guaranteed ability to access the records for the transparency that you note on the slide. And so I think this is a win-win for both. Obviously, there's some administrative burden, but that administrative burden is probably offset by the fact that if owners don't look at the website, we're taking dozens of hours to comply with these requests for these commonly or routinely accessed documents for unit owners and homeowners. And I think it's a good thing.
Right. And just to follow up a little bit on what Steve is saying from a little different perspective, this whole cat and mouse game that goes on with records only creates aggravation and agitation amongst the owners. It ends up showing up in board meetings. If the association has entered into a contract for something with the company to do whatever, and they did this through all the right processes, why not let the owner read the contract, and why not let the owner comment on it if they think that there's some issue? Instead, they get hidden. And then a complaint eventually gets filed with the Department of Business and Professional Regulations. Over 50% of the complaints that they get have to do with official records requests. So this is like, I have to take an old thing, welcome to the 90s. Most everything we get comes to us electronically. The contract is sent to us via PDF or DocuSign. The reserve study is sent to us via a PDF file. Most everything is in a computer-ready format. It's just not filed through a portal into places where they can easily be found. So I don't think this should be some huge burden on. And I fight for this, and when in Tallahassee, I'm one of the advocates for this, obviously, and I don't see it's a big burden. They got to put the documents somewhere. So either they're printing a file folder label and filing it away, or they're uploading it to the website.
Exactly. And thank you both for those points. And that transitions very nicely into the next section here about, do we need a portal too, or just a website? Kim, over to you.
In Florida, yes, you do need the portal. In fact, you could stick with the portal because they are much easier to maintain, probably less intimidating than a website. It is possible definitely to have both for an affordable cost. That way you can use the website kind of as a marketing tool, just to show off the best of your community, and then have the portal where all of your documents are contained, and only members can access that area. And Condo Control has lots of experience helping communities find the solution that works best for them. So we do understand what is required, and we can help communities comply.
Exactly. And more on that later, how we can help. Next, we want to just kind of poll the audience on, what are your biggest concerns regarding the new laws? And do you feel your community is prepared to comply with them? So please put your answers into the Zoom chat, which Richard will be open, and we'll see what everybody says here. So just a bit of a two-part question here. Biggest concerns regarding the new laws, and how prepared do you feel, or are you already prepared? maybe you already have a portal, a website, everything is all set up, but we want to kind of gauge how everyone's feeling about these. Okay, so into the Zoom chat, please put your answers. Okay, so let's see what we have here. Da, 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 da. Let's see. Richard, do you have the Zoom chat open?
The chat is open. We haven't got anyone typing in there. We've got a lot of people answering the poll, but not typing in the chat.
Okay, so please do put your answers into the Zoom Q&A, or sorry, into the chat, not the Q&A, the chat. There we go. Okay, no concerns, already have a website. Anything on the portal, interesting. Yeah, it depends on the number of units as well. Amending governing docs. Okay. Some people already have a portal and are ready to go. That's good to hear. Okay, I'll just give everybody another minute to answer.
And I see there's a question there about Florida co-ops requiring to have a website, and the statute did not find its way into 719. So the same laws that we're talking about for HOAs and condos are currently not in Chapter 719 for co-ops.
Stand by. It's almost best practices. I mean, that's the other thing. Well, people are asking the questions. This is kind of like a best practice of document management. And it'll make it a lot easier when somebody comes to buy a unit and they want to see the last two reserve studies, the budget, the board meeting minutes for the last three meetings, whatever they want to see. You'll if your website is or portal is either one is properly laid out, they should be able to find almost all those without the management company or manager needing to get involved. You do not, I saw a question that flashed by a while ago. You don't need to own your own website. You can host it with anybody you want. If your management company is offering you a website, you can host it with them. That was the question. From a technical perspective, this is your data. So you want to make sure that the agreement that you have with any third party that is managing or hosting your data, that you have the right to pull that data out of their system at any time.
All right, I think we're going to close the poll now. Thank you, everybody, for your input. All right, let's move on to the next section on HB 1021 and HB 1203. All right, Kim, over to you.
Okay, so this one is a little bit lengthy. Again, two different laws for HOAs and condos. So we'll start with condos this time. HB 1021 states that condominium directors must submit a certificate verifying completion of an educational curriculum that is at least 4 hours long and includes instructions on milestone inspections, structural integrity reserve studies, elections, record keeping, financial literacy and transparency, levying of fines and notices and meeting requirements. And this must be done within 90 days of appointment or election. So you just got elected, you must complete this course within 3 months of being elected. And the certificate of completion is good for up to 7 years. Board members must also certify in writing that they have read the association's governing documents, will work to uphold the documents to the best of their ability, and faithfully discharge their duties. And another thing, so 1 year after completing this mandatory certification, they must continue getting a 4-hour course every year. And the director must complete at least 1 hour of continued education about recent changes to the condominium laws and rules. So just ensuring that you know what is going on, and if you need to change any laws, that you are in a good position to do so. And they must certify on a form provided by Florida's Department of Business and Professional Regulation that they have completed the required requirements in writing, and then they hand all of this stuff essentially to the secretary to just demonstrate that all of the requirements have been met. Similar
Yeah, Kim,
Oh, yes.
that law used to actually provide an or, right? Either you take a certification class or you sign the piece of paper that says that you will uphold your documents and you've read them, and it's shifting to an and it's doubling the length of the class. It used to be 2 hours and now it's 4 hours. We typically say that once you're elected to the board, the first step is a mental health exam for questioning why you decided to do it in the first place, but then you got to take the class. And so the class covers a lot of topics. We're certified to teach it. The DBPR regulates certification for that. And so we got some good jokes, and I think a lot of providers try to make it fun and happy, but there's also a lot of nuts and bolts that is very helpful. And whether you're a newly elected director, or whether you're just looking for legal updates, years down the road after the initial, 4-hour requirement, they're great. They're fantastic classes. I know a lot of my colleagues who teach them do a great job. And but that certification needs to be in the file cabinet, right? We all know there's somebody who's going to make that records request, and Lewis is going to walk down and say, I want to see, it's not on the website, so where are all those certifications?
Right.
And if you're not certified, you're technically suspended until you get that certificate in the file cabinet. So give it to your secretary, give it to your property manager, get it in the file cabinet.
Right.
And online.
Just to Steve's point, not to pick on me, but in the official records section of 718, these certifications are required as official records because the association cannot allow you to remain on the board past 90 days if you have not handed them this certificate, which is interesting. But the most important thing to me about getting this education is new board members don't know what to expect. What does the law require? How does the law talk about meetings, quorums, and all that good stuff? And so they tend to turn to their property manager or property management company and say, hey, what does the law require that we do? And unfortunately in Florida, or fortunately in Florida, depending on which side of this you're on, the property managers, unless they're lawyers, can't answer that question. So they can a little bit, but really they're treading on a Supreme Court ruling that they aren't qualified to read the law. So anyway, the moral of the story is this is an official record. Boards will be more well educated. They'll be able to be more efficient in what they do. And again, I'm a big advocate of, putting oil on the water. Like this can eliminate a lot of the agita that goes on between owners and the board. If the board can speak authoritatively, I took this class, here's what they taught us.
I see there's a question from Anthony as well. So if you were elected before July 1, 2024, I got bad news for you. The idea is everyone's got to get recertified. Every single certification that was issued before July 1st, 2024 is effectively rescinded for the providers and the classes. So the idea here is that for condos, everyone needs to get re-upped in terms of the certification. And also concerning the 1 hour continuing education, unfortunately, there's no way of doing this yet. For community association managers, we have long had a mechanism and a vehicle to ask the DBPR to approve someone like myself to teach continuing education to managers. However, despite the fact that the statute says you annually have to complete 1 hour of continuing education for condos, and the next slide I'll talk about HOAs, but for condos, you have this 1 hour of continuing education requirement. There's no way of getting that approved quite yet. So we have the 4 hour classes approved. We're still waiting for Florida to give us the green light to be able to teach those continuing education classes. We presume it's going to be the same way as community association managers, but that doesn't exist yet. So that's an open question for us as well as people on the webinar.
So just and I'm just looking at a couple of the comments, and we could probably do this all day long, so this will be the last one, but somebody said, what about older people who don't understand how to use the portal? The association is not exempt from having paper records. The association has to provide you the records in a usable format, downloadable onto a handheld device. So if you want them printed out, you can even still get them printed out under the current law.
Yep.
But the one comment in here where the board is just refusing to do anything. If we get a record straightened out and DBPR doesn't have to spend half their time yelling at people for not delivering the contract, maybe DBPR will have more time to help with that exact question of, we don't have these records. That's a real serious one. So
just for the interest of time, I'm just going to move to the next
bill
here. Yeah, no worries. Kim, if you don't mind going through our HB 1203 here.
Absolutely. So this one is for HOA directors. Same idea. Within 90 days after being elected or appointed, they must complete the course that has been approved by the DBPR. They must submit this certificate of completion. This certificate is valid for up to 4 years, and directors must also complete continuing education annually, and it is 4 hours for associations with fewer than 2,500 parcels and 8 hours for associations with 2,500 or more parcels. In the grand scheme of things, not a lot of time, and as both of our experts have pointed out, it is truly helpful just to have that opportunity to learn and refresh. Good to point out as well that yes, association managers are also subject to continuing education, and under HB 1203, they are now required to complete at least 5 hours of continuing education. That specifically relates to homeowner associations, but this must be done every other year, and 3 hours of that must be related to record keeping.
Yes, so next, seeing how it's deter people from serving.
Yes, so probably not. In most cases, I don't think it is a lot of time, and definitely more benefits than drawbacks. And it can also help set your board up for success. Yeah, so I think the answer is probably no.
Yeah, and for board members to sign up for this training.
This is the link for the initial training once you get elected. So these are approved by the DBPR. You'll see like a check mark to see which ones are approved, and they also list the fees. Some of them are free, but some of them are a minimal cost.
Yeah, and we've included this link into the chat for people to check it out, and as well, I'll include it in the post-webinar email so everybody has that link available. Okay, and here we go.
And finally, how do you prove that the training was complete? I think we have covered that you do get the certificate once it's the course has been completed successfully, and you give it to your secretary or your property manager so they can keep it on file.
Okay, on to now the parking and backyard aesthetics bill, HB 1203.
Okay, so this seems simple, but definitely not a simple matter. Parking. So HB 1203 states that HOAs cannot prohibit personal or work vehicles, which are essentially pickup trucks. They are pickup trucks. That's probably the big issue, from parking in a homeowner's driveway, and they also cannot ban first responder vehicles from parking on public roads within the community. For backyard and aesthetics, same bill, unless prohibited by general law or ordinance, HOAs cannot outright ban boats, flags, vegetable gardens, clothing lines, or artificial turf in backyards if they are not visible from the parcel's frontage or an adjacent parcel, an adjacent common area, or a community golf course.
Yeah, Kim, these two laws have been flooding my inbox, since July 1st for sure, and they really are separate in how we look at them. The first one with the personal vehicles and trucks, the idea here is that if you have a truck or a car with decals or what would previously be construed as a commercial vehicle, you can park it anywhere you can park your personal four-door Honda Civic. Right. If you're able to park your vehicle in the driveway, you can park a truck in the driveway despite what your covenants say. And if your covenants require you to park trucks and commercial vehicles in a garage, an enclosed garage, the statute now says that is a prohibited provision, right? It's prohibited to do that because owners can park their work vehicle anywhere they can park their personal vehicle. Now, there is a commercial vehicle under the statute still. The definition of commercial vehicle, which can be prohibited, is just this massive 25,000, something like that, pound towing capacity vehicle. So almost everything that you would consider to be a truck or a commercial vehicle in your day-to-day life is going to be allowed to be parked anywhere your normal vehicle can be parked. Now, the question I always get is, Steve, does that mean I can park a truck anywhere I want in the property? And the answer is no. It's just treated the same way as a car. So if your covenants and your rules prohibit street parking between 11 p.m. and 6 a.m., it doesn't mean you can park your truck in the street from 11 p.m. to 6 a.m. It means that whatever rules are applicable to vehicles are effectively going to incorporate and be applied to trucks and commercial vehicles. We'll talk a little bit about whether this law applies to all communities. So for those of you who've seen other webinars, talk about Kaufman. We're going to talk about Kaufman shortly, and we'll save that discussion for then. But that's what the statute says today. And for the backyard storage, the big fear here was, oh no, my neighbor is going to park their boat in the backyard, and we're never going to be able to keep that boat out of the backyard, or this artificial turf idea. And the statute was not new this year. It was actually new 2 years ago. And it provided that the association can't regulate anything that can't be seen, was the idea. Is that if you can't see it from an adjoining next door lot or the front of the house, then the association can't regulate it. Not just that the association can't prohibit it, but that we can't regulate it. So if you had a rule, for example, saying no putting greens in the backyard, right? You can't have an artificial putting green in the backyard. Well, your covenants prohibit that, but if no one can see it, the idea is that the association shouldn't be able to tell you what you can and can't do in your backyard. And this most recent legislative change last year was to kind of expand the viewpoint, because the initial concern was, well, what about homes up to golf courses and lakes? Well, behind the home is not another parcel, not another lot. Behind the home is a golf course or a lake. And so the viewpoint was expanded this past year to say that if you can see it from the front, a side parcel, or a rear common area or golf course, then it can be regulated, right? That way the person with the pie-shaped lot up against the golf course can't put the boat in the backyard under the argument that, well, there's no home behind me. No, the statute was expanded to say we can regulate it if there's a golf course or common area behind us as well now. So these are very much hot button issues for homeowners associations, not really for condominium associations, but this has been a huge topic of comment, of discussion, of frustration. And for some people, blessing, some of these trucks are twice as much as a sports car. So it's an interesting development, the way the statute's going. I think Lewis has some thoughts on how we got here, which are interesting as well. But this is definitely a hot topic.
Right. Well, without going into the interesting way this all came about, because I'll just say it solved one person's problem in one county in the state of Florida to allow them to put turf in their backyard. And here we are, the Lawyers Retirement Act of 2024. I'll say this to the board members. This is what the law says. maybe it should be in your documents. It doesn't need to be in your documents, but everybody's going to come running around and say, well, wait a minute, if I go up on my roof, I can see it. And so therefore Bobby Jones should be fined or whatever, or Julie Jones. You got to like tamp this stuff down and apply some, the term is being thrown around so much anymore, we don't know what it means, some common sense. That if the flag doesn't really bother anybody, somebody puts a United States flag or the Florida flag, something that's not offensive up in their yard. It's like, reminds me of basketball. So many HOAs had restrictions on basketball nets and driveways. So everybody ran out and bought a portable one. They roll it out of the garage, they play basketball, right? So I just caution you, like, try not to make a big deal out of this, because the only person that benefits is Steve.
Well, it goes into the next section here about, reasonable limitations.
Yeah, so I think we did cover that essentially, that from the association's point of view, you want to treat this pickup trucks the same way that you would treat any other vehicle that has been permitted to park in the community. And good point, yes, some pickup trucks are way more expensive and luxurious than a four-door sedan.
Yeah.
It's not the money, but it's being consistent. If you, for example, have a level above ground and you have a weight limit on what vehicles can go, say, up that ramp. Well, you can still enforce that, even though it's an owner's pickup truck. They aren't allowed to drive there. So you want to make sure that if you have any of those kinds of rules or regulations, that they dovetail into, might have to amend them to dovetail into this law, that you still have the right to not allow a 10,000-pound vehicle to drive up the ramp.
Absolutely.
Yeah.
And then as for the backyard storage and aesthetics, again, treating it like you'd treat pretty much anything else. Make sure that whatever is there, like if it is interfering with someone's safety or it's causing a potential hazard, then definitely needs to be addressed. If it's a flag, perhaps, you create rules that are very specific so that owners can still enjoy their property without creating too much conflict.
Anything about the vegetable gardens as well?
I like the garden one because I always enjoyed getting up in the morning and seeing the deer in my front yard. Well, I can't help it that whatever kind of bush was planted there, they liked to eat. This actually this will become some other kind of bone of contention as to whether or not whether it's Mother Nature or whether you are intentionally planting things that invasive species like deers like to eat.
Mm-hmm.
Well, I think the idea is the general nuisance idea, right? Certain fruit plants, fruit trees are going to drop fruit. If the owners don't take care of it, it brings rodents and nuisance into the community. Likewise, wild deer in the front yard is enjoyable to many. I'm sure we don't want bears likewise doing the same thing. So it's a weighing and balancing of interests. So when we have permittance of vegetable gardens, which are a great idea, that's great. But to the extent that it causes nuisances, now we're talking about another section of the covenants, which are typically going to be invoked. And so it's a balancing act for sure. But the idea of a reasonable restriction, as you note, is what we're talking about, and that's going to be different for each community.
Right, and if as the manager or as the board, maybe you should know what things you don't want people to plant, so that you can say, these are the kinds of things that we consider to be not allowable under the statute, not allowable under our rules. So that, again, so the owners aren't planting whatever, the fruit tree, and then finding out that that's not really allowed, and well, why isn't it allowed? And I keep my yard clean and blah, blah, blah. It's like the board has to act proactive, has to be proactive on these kinds of things. Or you can just have fights all the time.
Absolutely. And in terms of owners, definitely helps if they take some responsibility as well. Start by, yes, respecting their neighbors and abiding by the covenants. Those are the two big things. You may not like the rules, but unfortunately, you have to follow them because you agreed to do so when you joined the community.
Yep, and I'm just going to move on to the next bill here, HB 59, distribution of information.
Okay, this one is short and sweet. So associations must distribute a copy of their rules and covenants to all members. And if the HOA amends the rules, they must provide an updated copy to all members as well. And this is applicable to homeowners associations.
Mhm.
Should clarify that. So can you distribute documents electronically? Yes, absolutely. They can do this through the association's website or through email. So there's another reason to have a website. But it is very important to note that you cannot just send, everyone an electronic copy without first getting consent. So you do need to ask them to opt in to receive an electronic notice. And once that information has been you've received that from the owner, then you may send documents electronically. And not only is this easier, but in our experience, we've seen that communities can reduce paper and mailing costs by at least 25% when they start using a platform like Condo Control. So if you are planning to use a website, definitely okay. And you can also post a complete copy of the rules and covenants or a link to the documents on the homepage, as long as it's accessible to members. And the association has sent a notice to each member of its intent to utilize the website this way. So definitely lots and lots of communication if you are planning to send information electronically.
Yep. Thank you, Kim. And just for interest of time, I'm going to just move on next now to Kaufman language. And Steve, I will pass it over to you.
Yeah, so we're not going to, but we could talk for an hour on Kaufman. Never in my career have I spoken more about Kaufman than I have in the last 8 months. And so originally it was a condo concept. It has to do with the fact that condominiums are creatures of statute and what law applies. And so when you have a legislative change, the Florida Constitution says that the legislature cannot impair existing contract rights substantively. So when our legislature adopts a substantive statute, the argument is that it only applies prospectively. It doesn't apply retroactively to existing contracts. And all of your declarations of condominium or covenants, they're contracts. And so in the condo world, it was always, well, if your declaration says that you're subject to Chapter 718, as amended from time to time, if it says that, then you are opting in to allowing the contract to be molded and changed as the legislature impairs the rights in the document. But if you don't have that language, it'll say under Chapter 718 as in effect on the date hereof, or as of the recording date. If it says that, you kind of have the anti-Kaufman language, which says we are frozen in time. Now, if you have developer drafted documents, you probably don't have Kaufman language. And the reason is because developers don't want surprises. They don't want their obligations to change in the midst of development. And so they intentionally say, we're locking in as of the date of recording the declaration. Now, why it's important is because there's a lot of effort that goes into figuring out what happens when the statute says something than what the declaration says. The best example I can give you before trucks is going to be this idea of safe harbor and assessments. So many of you may recall during the financial crisis, the foreclosures. And in the homeowners association world, the statute for a long time didn't say anything about this. And then in 2007, it said mortgage holders owe something. They owe 1% or 12 months of the debt or something to the association. And there's a lot of fights over, in one particular, a loan that was granted in 2004 and was foreclosed in 2008. And the association said, congratulations, bank, you took title and helped give me my money. And the bank said, I don't owe you anything because the declaration does not have Kaufman language. They didn't say that, but that's the argument, because they didn't have Kaufman language. And because when I lent the money, the contract, the declaration says I owe you zero. And the bank won. And so when this legislature imposes requirements on the association owners or third parties, the idea is that it can only be applied prospectively to new covenants that are drafted and recorded after the legislation is drafted and recorded. But it gets more fun, more complicated, more expensive to figure out, because we're only talking about substantive statutes. Procedural and remedial type statutes can apply both ways. So talking about trucks, the argument is that this prohibition on restricting trucks is a substantive statute. And so many of my HOA clients are saying, well, if I don't have Kaufman language, the legislature can't prohibit me from preventing trucks anymore or commercial vehicles, that my covenants should remain untouched by the legislature's in quote unquote impairment. And so we're going to see where the courts go on that. But it's this interesting concept of, well, when we have a conflict or inconsistency maybe of the statute and our declaration, what controls? It's a very difficult, very consuming, very frankly, gray area analysis for many questions. But you should be asking yourself, if we are updating our documents, do we want to include Kaufman? Is this something we care about? Now, it's a double-edged sword. Maybe you don't want Kaufman because you don't want to give up your right to prohibit trucks or commercial vehicles. But in the same token, maybe you're not able to take advantage of other really great statutes, which you do want. So it's worth a conversation with your counsel, with management, about trying to figure out where to go from here. But this is a word, a phrase, this Kaufman language, again, in 16 years, I've never spoken about it as much as I have in the last 8 months. And it's not going away while we try to figure out the truck thing for sure in the near future. But something to consider.
Yep, absolutely. I'm just going to move forward again now to how communities can comply, just going through, some of the ways, and starting with websites, as we mentioned before. So if you don't know where to start, you can speak with a professional website developer or condo control. We can help communities with compliance. And if the board or management company plans to manage the site itself, you'll want to make sure it's easy to use and ensure it's password protected, having that section to upload documents and uploading amended documents as soon as possible. Okay, and then for board certification, it's very important to upload the certificate to a designated file that can only be accessed by people with authorization. And it's also suggested that you create kind of a welcome package for new board members, just to get them oriented, which could include, info about getting certified and having those proper website and links available. Okay, and then for the parking and backyard aesthetics laws, you need to ensure community members are aware of the reasonable limitations and address violations using the same processes that are currently in place, as we discussed. And lastly, document distribution. Okay, so be sure to gather the preferences from your community members. And, in terms of gathering what the preferences are for receiving, through e-consent, or if they prefer through print. Now, I'm just going to quickly do this one poll. So when it comes to distributing updated governing documents to owners, which delivery method does your community use? So we'll just give everybody a minute to answer this poll. Please fill out your answer, as you can see in the pop-up here. Okay, we have a direct link in the lead. What's common is email or digital newsletter as well. Okay. Very good. And, all right. Looks like we have a good number of people answering here, and in the lead is email or digital newsletter. Reflecting the modern day. All right. Okay, just for the interest of time, I'm going to end the poll. Thank you, everybody, for submitting your answers. It looks like email or digital newsletter is the top, and then direct link on association's website in second place. Okay, perfect. All right, thank you, everybody. Next, we'll just quickly go over some more questions from our experts. So with the first question being, what advice do you have for communities that don't have Kaufman language now? I don't know, Steve, if you already addressed this, we can lightly answer it again.
Yeah, the light
Yeah.
answer is remember there's the good and the bad. It's a double-edged sword. And I think most clients would prefer to have it to avoid the question and the cost of figuring out what the law is. But you do need to consider the implications, good and bad.
Mhm. And then second question, what's been the most common challenge relating to these new laws that clients have come to you for, and how have you helped them?
For me, it's been just some very I don't want to call it poor drafting, but ambiguous drafting in the statute. You know, we have some new changes for condos about special assessment notices and closing contracts with the notice. People don't know what that means.
Mm.
There's a lot of new laws talk about fraudulent voting activity and what constitutes fraudulent voting activity and what's the criminal sanction that applies to it. So I think we're in dire need of some clarification. And I know this is Lewis's world as well, but the reserve for high rises and mid rises, 3 stories and higher, the SIRS and the milestone inspection reports. Coming to year end, that was a rush for people to try and figure out. And I'm sure as Lewis probably knows, a lot of communities still haven't done it who are required to just because of the backlog.
Right. But wasn't out for them if they have contracted, if you've contracted to get it done. And there's they try their best in Tallahassee to write these things. And I don't know if anybody on the call has ever been in negotiated a contract or something complicated. Turns out that the next day, nobody remembers exactly what they agreed to. And so the words look really good the first day, but then when it gets printed, we don't know what they mean. So again, there's just some good common sense. If you have 60 people voting for an election and there's 72 ballots, well, yeah, that's not right. So just don't let that happen. You know, because there are board members sitting in jail today, former board members sitting in jail today for stealing money, for playing with the votes, for making stuff up as they went along. And so there's kind of like a sledgehammer in statute that most associations, I could almost say like the very vast majority don't have any fraud going on, don't have to worry about it, but just be aware that that's out there.
I do want to move on to the next question. So just overall, what is the best way for communities to implement new laws?
Well, one way is to do what you're doing. Watch webinars and educational materials on by Condo Control and others that are educating board members. We found that a lot of clients were asking us for checklists, and so we actually prepared a checklist for condo and checklist for HOA. The condo statute had a lot of don't do this, don't do that, or else you'll get thrown in jail. And the HOA statute had a lot of do this, do that. So there are definitely some more action items for the HOA statute, but those checklists are great. And be good stewards, I think, is at the end of the day. If you're exercising your fiduciary duty, you're relying on third-party opinions, exercising due diligence, doing it in the open, then you'll be fine. And just learn and implement what you're doing in a transparent way.
Yeah. Anything to add, Lewis?
Well, the board has to remember they're running a business, and there are rules, and these are the laws. And I'm a big advocate. I'm a big advocate of CAI. I think that Community Association Institute, I think they do a great job. They represent lawyers, bankers, insurance people, homeowners, up in Tallahassee and in the country.
Mhm.
So I'm not making a plug for them. There's like a half a dozen good organizations to belong to where there's things you can subscribe to online. So that every month you get an update, you get a condo, how to deal with the new swimming pool regulation. You know, this stuff comes to you so easily. So there's no excuse to not be a good board member. There's no excuse to not understand because there's so many ways you can get that knowledge. And if you have a law firm, they're probably sending you out a memo every so often, summarizing what you need to be doing to be in compliance with the law.
And that transitions nicely into how we can help. Just as a reminder that we said throughout the presentation about condo control and how we can help communities with compliance, in particular, making the processes more convenient. So not only does condo control offer personalized website development for both condos and HOAs, but the platform also offers many helpful features for managing documents, communications, financials, and more, all in one place, a portal. And whether you're using desktop, tablet, or a smartphone, in the office or at home or on the go, you can download the app on the App Store or Google Play, and our online software can be used to also help with architectural change requests and for tracking violations of community rules. So another exciting feature there. If you are interested in learning more about condo control, please reach out to inquiries@condocontrol.com for more info. And that is the presentation component for today. Thank you so much, Lewis and Steve, for being our guest speakers. We're now going to start the Q&A session. So I'm just going to see what we have here. We have about 10 minutes left in the presentations or in the webinar. So we'll take a few questions and then let's see what we got. So let's start here. Okay, from Odina, are meeting minutes part of the homeowner's right to request?
Heck yeah.
Yeah.
Minutes are mandatory forever. So you're able to inspect all minutes except for minutes dealing with personnel matters or that are protected by attorney-client privilege.
Okay.
What is not covered is the quality of the minutes and whether or not audio recordings of meetings should be considered the minutes. These are things you can discuss with your board or you're on the board to consider that the recording of the meeting, especially in the modern age of AI transcription services, really are the minutes of the meeting. And
but the administrative code provides that you have to keep recordings until the minutes are reduced to writing. And actually the recordings could then be deleted as they apply to condos. And this is where you get differing opinions. In my world, we say they're called minutes, not hours, right? For a reason. And that's because the more you put in the minutes, the more you're going to misquote people and get things wrong. I've been misquoted in more minutes than I care to count. And so the more people try to summarize what I say in minutes, the more they get it wrong. So take that for what it's worth. Everyone's different, but from my perspective, from the board's legal perspective, you can't put things in minutes that help you. But you need to have the statutes that you have to have who was there, how they voted, who made motions in seconds, and transcripts are, again, in my opinion, unnecessary.
And from an owner's perspective, we are the owners group. We are fighting to make those recordings since they take up no space anymore. There's no more like, reel-to-reel tape deck holding the stuff, because there are things that are discussed that get put down into the minutes that are not. It's hard to go back a year later and go like, well, why did we make this decision? Or why did the last board make that decision? We now have this contract. We don't understand what they were thinking. And there's no way to go back and get that understanding.
Okay, I'm just going to go on to the next question from Dean for HB 1021. Is there a minimum, quote, size of the association required before you have to comply?
1021, was that the website one?
Kim,
I forget the numbers.
yeah, I know, me too.
I think they're asking whether if they're just a very small association, do they have to comply with the law?
Sorry, that's for training.
Oh, the training applies to all, it applies to everyone who's willing to serve on a condo or an HOA board. Doesn't matter what size you are. The only difference is for HOAs, if you're larger than 2,500 homes, as Kim's slide said, you have 8 hours of continuing education every year. In less than 2,500 homes, you're 4 hours continuing education every year. And condominiums have 1 hour of continuing education every year. The statute says annually, but as we noted earlier, there's no continuing education approved yet that I'm aware of.
For about Kaufman language here, a question from Geraldine. Can Kaufman language be in the bylaws only and not the declaration?
So it's typically, it's a condo concept because condominiums are created by the Condominium Act and the declaration. We look for wherever it's located. Typically in the condo, it's very clear. It says in the submission statement on the first page, usually it says this condominium is subject to Chapter 718, either period or is amended from time to time. But it's very common or very possible that in your articles of incorporation or bylaws, you have a statement of intention to be bound by the law as amended. So you have to look at all three.
Okay. From Melinda, does the board have to allow a call-in option for board meetings?
No.
No.
It says directors may participate remotely via phone or computer Zoom, but there is no guarantee of an owner to be able to call in or Zoom and participate. That's optional.
Sherry asks, if you completed the certification as a board of director after July 1st, 2024, do you have to do the 4-hour again?
If you took so there was this weird period between July 1 and like October something where we had the 4-hour classes approved. If you only took the 2-hour class in that little window of time, you didn't take therefore the 4-hour class. And so you got to take the 4-hour class. If you took it after July 1, it would have to be one that was approved by the DDPR. We didn't get those approvals till like October-ish. So it depends if you took an approved class.
Okay, well, just looking at the time, we'll take a couple more questions. Do rule amendments require 30 days notice along with the proposed amendment?
No. Statutes say that a rule impacting the use of a lot, unit, or parcel must have 14 days mailed and posted notice. So if we're regulating what you can do on your dirt or in your unit, it has to have at least 14 days mailed and posted notice. Your bylaws might require 30, which is specific to your community, but the statute would not require 30.
Okay, and then this last question here from would you recommend a shared website for a community with several singular registered entities? We have 5 in my complex.
Even though you might have 5 different similar condominiums, if they're each their own corporation, they are their own corporation. Right? Those are proprietary. So I would recommend each corporation being able to keep its information to its own members.
Awesome.
Well, and technically a web platform could be the same platform used for multiple associations.
Oh, yeah.
Because each one is a separate contract that the association has entered into. So there's definitely a way to do that from a cost share, in order to share costs. There's some association, multi-condominium associations. They got 9 different associations on the same property. They're probably going to be doing that kind of shared thing, but it's an agreement between Association A and the web provider. So that constitutes having your own website.
All right. Thank you so much, everyone, for all of your questions. We're going to do our best to, address more afterwards in terms of the post-webinar email. But for our current Condo Control customers, just wanted to remind them about a Spring Into Rewards referral program we currently have. So when you refer a new customer, you will earn a special reward as our way of saying thanks. You can, choose your reward, either a $250 gift card, up to $2,000 credit on your bill, or a $500 charitable donation in your name. So it's pretty simple. If you refer a new customer and once they sign up, you do get rewarded. And please ask your customer success manager to submit your referral. And thank you all for attending today's webinar. A big thanks to our guest speakers. If you do want to know more information about Condo Control, you can go to condocontrol.com. For our upcoming webinars, go to events.condocontrol.com, or you can also contact us toll free at 1-888-762-6636. All right. Thank you so much, everyone, for your time today, and we hope you have a great day.
Thank you so much.
All right. Bye.